Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly telephone call, and as you logged into the conference, you would have heard cautions that this is a general knowledge call. We cannot tailor-make our answers to depth enough without a proper consultation, but we do the best we can to at least show you the direction, and this does not establish an attorney-client relationship. With that, let me just make sure that everybody can hear me okay.
The conference is now in conversation mode.
I can hear you. You can hear us? Everybody can hear me, guys? All okay?
Yes, we can.
Thank you. Excellent. Okay.
The conference is now in presentation mode.
So let's get started. I may not have time for new questions. We have enough here to last us through the hour that we will spend on this. I did not mark any questions as frequently asked questions because I did not think there was any such thing here today. So let me begin with the question number 2, which is H-1B holder owning illegal stocks. So the problem here is if an H-1B holder buys cannabis stock for pot or for the trade, how does that impact the non-immigrant visa? And I remember there being a lot of discussion about this. Okay, there have been several scholarly articles published on this, looking at various angles. I have never studied this issue in great detail, but I can tell you that this could be a problem. Why? Because we have a very strange situation in the United States, where many states have legalized pot, but federal government considers it to be illegal. So immigration law being federal law, you could be perfectly obeying the law in a state, but under federal law, you could be breaking the law. And that could become a problem. So to answer your question, could this be a problem? The answer is yes. Do I know the answer to the exact detail? No, because I have to look at all the angles it presents. So owning stock in pot, is it legal or not? Definitely problematic, no question about it. But here is the interesting question. What if the Biden administration legalizes marijuana? Does that make things okay? And my guess would be that it should, even though the violations that you committed by owning marijuana stock were before the laws became effective. I am hoping that if such laws are passed, they will be retroactive. Anyhow, there is no clear answer on this. Therefore, it is better not to own it. Should you divest it? That's your call. But you had previously owned them. Since you don't own them currently, I think you should be okay. Press *5 on your phone if you have a question following this one. Any follow-up question on this topic that I just discussed? So the answer to your question is potentially problematic, but since you've already divested yourself of them, we can only hope that it will not become a problem further down the road. Question number 3 presents a very sympathetic and odd situation where mother and sister have tourist visa which expires in Feb 2022. Mother is a domestic abuse victim. Because of their situation, I've asked them to fly to the United States to temporarily keep them safe. They have received death threats after they came and are unable to return. Well, if they have received death threats, I think the first thing you should do is lodge police complaints so that you can actually back up your allegations with some documentation. You become a green card holder. Is there any way you could sponsor your mother to keep her safe till I become a citizen? And the answer is not. Well, let me take it back a little bit. There have been situations where we've been able to extend families B2 visas based upon certain conditions. What are those conditions? So, for example, before homosexuality became legalized in the United States, it used to be a problem. Let's say somebody is coming from Germany and they are, let's say, a married couple under German laws, but USA does not recognize at that point, let's say, the gay marriages. How do those people come? If the principal comes on H1, can his husband come on H4? And the answer is no. In those circumstances, consulate used to issue B2 visas, and they would be extended as long as the H1 was in force. So there were actually visa classes where somebody does not technically qualify for a derivative, but we give them on an ongoing basis a B2 extension. And they used to do that for, and they still do it for, parents also. So we've had a few cases where an individual, a physician, was on an H1. Dad came from India, pretty advanced diabetic, and needed a lot of care. There was nobody in India to take care of him. So we kept extending the B2 for a few years. We've also had a case where the H1 beneficiary had a stroke, not the beneficiary, the H1 principal had a stroke, and the H4 we've been extending not as H4 but as a B2 for many years now, at least 2-3 years. I don't know exactly where they are right now, but we've done quite a few extensions. So could your mother come under that category? I do not know the answer to that question, but if you have filed a police complaint, it might be worth trying to extend her B2. Now, the fact that your mother, and you cannot apply for her until you become a US citizen. Your mother's sister applied for your mom, that does not get expedited. I do not know of any way to expedite a green card application out of a priority date queue. Can your sister apply for a student visa? The answer is yes, but you've got to make sure that you're able to convince the government that when she came into the United States, she was not already intending to file for a student visa. Okay, because that would become a misuse of the tourist visa if you try to change your status to a much more long-term visa, such as a student visa. Okay, so but do talk with a lawyer before you do this. I'm just giving you some of the options. That's a possibility, but it should be explored carefully. Can a US citizen sponsor my mother for an H2B visa? H2Bs are not available for Indian citizens. Last time I checked, we don't do H2Bs. Not really fully on top of that field, but I'm pretty sure that H2B is not available for Indian citizens. When should we apply for a B1, B2 extension? You should try to, if the aim is to try to keep them here as much as possible, you should apply in the last month of their 6-month stay, request for a 6-month extension, and if the extension is granted within the time you've asked for, great. If not, you could probably put in another extension before the 6 months are up and the case is still pending. So daisy chain, before the 6 months that you asked for expire, file another extension. Can you keep them legally here till you become a US citizen? Probably not. That's a long time. But can you try it? You can, especially if you can document that she has a threat of bodily injury and harm if she were to return to India. *5 if you have a follow-up question on this. What I have just discussed, press *5 if you have a follow-up question. People who just logged in, I might remind you that we may not have time for new questions today because we have enough for the hour. Okay, next question number 4 is merger effect on priority dates if EB2 to EB3 downgrade, rejection and H1 transfer. Working for Company A, but last year, Company A got acquired or merged into Company B. They are amending the I-140, but Company B closed permanently the green card perm work location site and asked to work from home for all employees. Company B exists in another MSA. So job exists, but not at the work site mentioned in the perm location, the metropolitan statistical area. So my green card EB2 category did not downgrade to EB3 in October. Is it possible to amend the perm worksite location while they are amending I-140 in a merger acquisition situation? Okay. First of all, if the merger acquisition leads to what is called a successor in interest, that's a term of art which basically means a new company steps into the shoes of the old company, assuming all their rights and responsibilities in relation to immigration. We call them successor in interest. When you have a successor in interest, they can amend, but it's a very valid problem. What if the MSA has changed? And the answer to that question is there is no known solution to that problem. I have seen cases where that occurred. I have raised the same question, and there is no clear answer to that. Normally, I have seen government approve these cases for successor in interest amendments of I-140, even if the primary work site is gone. Okay? You cannot amend a perm application once it's been granted. You can only file a new one. What are the consequences for employees who were not able to downgrade to EB3 when the worksite location is closed and moved to a different? That's the same question as before, that the government might approve the successor in interest. Question number 3, Company B is amending I-140, but currently amendment is not done and still on Company A's name. Will I be able to port the priority date? And the answer is, from what I remember, there is a weird little quirk in the regulations that were promulgated effective January 17th, 2017. Those regulations say that you will keep your priority date the moment your I-140 is approved. So that appears to be clear, right? But then there is another regulation that I don't remember exactly the wording of, where if the business closes, the government can go back and revoke the I-140. I don't think that should affect your priority date, but I'm throwing it out there just to let you know that there is a little gray area. I don't think you're going to have a problem, but nevertheless, there is a discrepancy in the regulations. Current priority date is EB2, and after my H1 transfer for some reason, if new company C is willing to file in EB3 only and not in EB2, can I still port the same date? And the answer is yes. And EB2 priority date can be ported to EB3, EB1. EB1 can be ported to EB2, EB3. It can be done across categories. The priority date doesn't care what category you are. Okay? If I start the green card perm process again with company C, can I use the old approved I-140 to extend my H1B? And the answer is yes, but there are a couple of caveats there. One is, remember the regulation I told you about where they can go back and revoke the I-140? Can it still be used as a part of your H1B extension even though it has been revoked? I think so, because if I remember correctly, the regulations take away that benefit from you only if it is for fraud and misrepresentation. Your I-140 has been revoked. Just because an old company stopped doing business, it should not be revoked. And in any case, there is a successor in interest in place, albeit from a different geographical location. So there are some gray areas, some doubts here, but overall it looks like you're going to be okay. So if your wife's H4 is pending for the last 6 months, is it okay to transfer to a new job? I think so. Would it cause any other delays to your wife's H4 EAD? I don't think so. I certainly don't think so. Okay. So there is a hand up already. If you have any follow-up questions on what I discussed, raise your hands. I'll go ahead and talk with the person who has their hand up. Area code 856, where are you calling from?
afternoon, Rajiv. I'm calling from New Jersey.
New Jersey, okay. How can I help you?
This is related to the same question, but slightly.
I can barely hear you, sir. Sir, I can barely hear you. Could you get closer to your phone?
Sir, yeah, are you able to hear me now?
Little bit better. Just speak louder, please.
Yeah, my question is kind of related to the same situation, so that's why I just wanted to ask if you could kind of, thanks again for your time first.
Of course.
Basically, like my company, because of COVID, may no longer be able to kind of sustain business, and it's kind of going off. So they expect to kind of remerge with some other business right now, like after July of this year. So we have been told of that. So my only question was like they did actually apply my downgrade process in October, and my 485 and a new I-140 was also applied along with it. They did mention that they won't be doing anything until July, like when the whole decision would be taken for the regarding business and everything. So my only question was, given I-140 and 485 may be pending, given how the backlogs are right now, would we still be able to hold on to the 485 application, given that it would be 180 days?
I think, well, 180 days don't count until the I-140 is approved. So unless the I-140 is approved, the fact that your 485 has been pending 180 days does not matter. Okay. I think you have a couple of problematic areas. So if the old company closes business, they have a I-140 pending and they've sold their company to somebody else, government may come back to you and say you have to file another I-140 for change to a successor in interest. At that point, I think you should be looking at a court battle. You should definitely sue them because it's very unfair for them to create a procedural hurdle. Is it illegal? Unfair, yes. Illegal, I don't know. A court will decide for you. So they could come back and say, well, no, you have the old company is gone. The new one has not yet filed an amendment of the I-140. Therefore, the downgrade is rejected because the company that filed it no longer exists. Okay.
And given that my 140 EB2 was approved, like it's been approved, like
yeah, that's okay. That will be fine. That you can file a successor in interest on the EB2 and transfer it over to the new company if they qualify. It's the I-140 that is pending that causes me concern. Okay.
So, but because the I-140 from the EB3 is pending, it won't be of any help with the 485 application.
It might not be. I can't predict. Okay. There's no clear answer to this also. Good luck.
Okay, thank you.
You're welcome. Okay, let's go on to question number 5. So this is H4 to change of status and aging out. Son is turning 21 in August, currently on H4, full-time student. As per that's my recommendations, I filed the application for his F1 visa. He's also included in the 485 petition as a part of the EB3 downgrade. My question is, if the USCIS does not adjudicate his F1 before he turns 21, can the I-140 processing time be used for extending his H4? No. No. Well, no, let me take that back. I'm not sure that child status, I don't think CSPA applies to non-immigrant visas. Hey, I could be wrong. It's such a basic question in some ways, but we've never come across this situation in exactly the same format. My very strong guess is that CSPA does not protect H4 visas. Okay? It only protects green cards. On another note, the USCIS extended the 797 approval for my wife to the same period when my son turned 21. I do not understand that question. If you're on the phone, press *5. I would like to understand what the question is. *5. Okay, so you're not here. I have no way of understanding this question. USCIS extended the I-797 approval for my wife to the same period when my son turned 21. I don't know what that means, sir. Sorry. Next question, number 6. There's a difference in the I-94 expiration date on I-797A. Expiration date of I-94 for both H-1B and my spouse H-4 is not the same at the bottom of the page on the most recent I-94 downloaded from CBP. Oh, wait a minute. The I-94 that you download from CBP and the I-94 that you... Oh, somebody just put up their hands. The I-94 that you get at the bottom of the 797, I don't think they are the same. I've never had to actually download them, but I don't think they are the same. And whichever is the most recently issued one, that's the one that should matter. And I suspect that's probably the one that came with your H-1B approval. So they are not the same. You can't just download. Okay. If you have traveled outside the country after your current H-1B was approved, then the I-94 that you got when you came back is the one that matters. Okay. So expiry date on the most recent I-94 is June 2019, whereas the one on the 797A is 2021. So there must be some kind of a problem that they gave you when you came back a shorter duration H1. And this can be a problem because you could be subject to a 10-year bar. In 2020 September 6th, 2019 is when your I-94 expires. So this should be looked at very carefully. Contact your lawyers, have a detailed discussion with them. Not sure exactly what happened, but this could become quite problematic. Okay. So the reason you have a shorter duration I-94 and your wife has a different one, because your wife's would depend upon the I-94 that came with the H-1B approval, the 797, and yours is based upon your exit and entry, which gave you 2019. And by the way, she is also out of status if you are. She's just not unlawfully present probably. Okay. So this needs to be addressed in great detail. Not only she's out of status and you are unlawfully present. What is the difference? Well, if her I-94 is still valid but you are out of status, she is not unlawfully present because she has an I-94 that is valid. But she's out of status because her husband is out of status. So you definitely need to talk with a lawyer in great detail. Go over your options. This is problematic. Not an easy question to resolve. Okay. Let's go to area code 669. Area code 669, where are you calling from? Area code 669.
Rajiv ji, this is from California.
Yes, sir. How can I help you? Do you have a follow-up question?
Sorry, Rajiv ji, this is not about this question, but the earlier question for the merger effect. Is it okay if I ask now, or?
Well, I would appreciate it if you keep it together because the recording becomes a hassle. Nevertheless, we'll do the best we can. Please try to keep the questions together. What is your question? Go ahead.
So, the merger effect question which we had earlier.
Yep.
So, like I mentioned, the current 140 is still on the company A's name with the original company's name.
Mm-hmm.
So, if I have to move to a new company, do you recommend amending that 140 to the current company's name and then move to a new company like company C?
I would have to look at the regulations to assess the impact of the regulations on the decisions that you make. But I see, it all depends. The regulation that bothers me is the one that says if a business is closed down, the government can go and revoke the I-140. I want to see its interaction with the regulation that allows you to preserve your I-140 and to preserve your priority date. I think you would be okay, but I would not want to give you an opinion without double checking. And there's no point in having another lawyer look at it. If you already have lawyers, talk to them, ask them what their opinion is. Okay.
And Rajiv, when you say revoke the 140, then that will not, that I will not be able to use that for H-1B extensions also?
That's exactly what I said. I don't know the impact of that revocation. There is a little gray area, and somebody might have to even go back and look at the comments USCIS has made when they promulgated the regulations. So some deep diving is needed. It's not something we can resolve on a surface review. Okay?
Okay, Rajiv, and I apologize for jumping
No,
in.
that's okay. That happens. But I just like to keep it all together. Otherwise, the discussion is scattered. Okay, it's like a fragmented hard drive. Information is all over the place. All right.
I understand. Thank you.
Good luck.
Thank you very much.
So then back to where were we? We did the aging out. Then we did the different I-94s. I said, talk to a lawyer. This can be a problem. Do you have any follow-up question on this? The different dates on the I-94? *5. Okay. So now the next question, number 7, is for I-485 downgrading from EB2 to EB3. Oh, by the way, there's somebody here on with a question on DV, the diversity visa, the lottery. If you are here, press *5. Okay. Let me tell you what I don't know. Area code 847. Where are you calling from?
I'm calling from Columbus, Ohio.
Okay. And you have a question of...
But my question is not directly...
Okay. Your question...
I did not raise that question, but it was something...
No. Do you have a question about... Sir, do you have a question about diversity visa?
Yes. No, sorry.
Okay, no. Press *5 again so you can get out of the queue. Okay. So the reason I asked the diversity visa person to press *5 is because I don't know the answer to that question. We don't do diversity visas, but I can give you some guidance on what you should do next. Anyhow, since you're not here, I'll come to that question eventually. I was hoping not to keep you waiting. Okay, so downgrading EB2 to EB3. My I-140 is approved in EB2 and I-485 is pending less than 180 days. Now my EB2 priority date for date of final action became current in EB3. I'm planning to downgrade from EB2 to EB3. What is the application process? So basically, the process is that if your date is current, you would apply for EB2 to EB3 downgrade as well as the 485 at the same time and request that a new I-140 be approved under the category of EB3. When we do downgrade, filing I-140 for EB3 is sufficient. It's called interfiling. Well, if you have, I don't understand why you are, I see what you're trying to do is you are trying to get even a faster action than you already have a 485 pending. So yeah, you could interfile. You could just file the I-140 and request that the I-485 be attached to the EB3 I-140. Later on, you can always go back to the EB2. What I would suggest is first get the I-140 approval and then ask for, seeing how the dates are moving, then ask for the government to attach the EB3 to your 485 if the EB3 dates are still favorable. Technically, the government is supposed to do it themselves. That's something they should be doing it. But you can always push it by opening a service request. So my suggestion would be, don't do interfiling right now, just get the I-140 for EB3 approved. Once that is approved, the dates are still good for you, do an interfiling on the I-140 approval for EB3. Okay. If I want to downgrade from EB2 to EB3, can dependents use EB2 EAD during this time? See, that's something I've never understood why that is a problem. Personally, I don't see why not. Because you still have an EB2 case. I do not know why your dependents cannot use EB2 EAD. Every now and then I hear other lawyers or people say that that's a problem. I personally don't know why. I would like to see their reasons. In my view, you can continue using the EB2 EAD even when the EB3 I-140 is pending or approved. What will be the application fee, lawyer fees? You know what? I do not know anything about our fees. But we have a fee page on our website. If you go to immigration.com and you go to the very top page, the top of the page, there's a ribbon that says Home, About Us. It's a gray ribbon. One of the links is to our fees. If you want more detail, you can send an email to our VP Operations and Legal. She's suman@immigration.com. S as in Sam, U, M as in Mary, A, N as in Nancy, Suman, S-U-M-A-N, suman@immigration.com. Actually, if you put down anything at all, if you just put down Joe Biden at immigration.com, it goes to Sumanji. All the emails without a particular address go to her. Okay, so you can just ask her your questions. You can let her know that you talked to me during the conference and you would like to know our fees, etc. I have no idea what we charge. *5 if you have a follow-up question on this. *5. Okay. Oh, there's one. 847. Area code 847. Where are you calling from?
Columbus, Ohio.
Yes, sir. How can I help you?
Yeah, I have a question that is tied to I-485 that was filed recently. So my dependent wife, like H4 wife, we are waiting for H4 EAD, but it's more than 7-8 months now. Meanwhile, if I get 485 EAD, can my wife work on 485 EAD without
Absolutely.
jeopardizing H4 status?
No. The moment you start using 480, your EAD, your H4 is gone. Okay. But you can always revert back to H4 by stepping outside USA and coming back with H4 visa. It's not that big a deal.
Oh, even for H1 or H4, if they start using EAD, then basically it's not H status, but parolee kind of status.
Yes, they become authorized period of stay rather than in status, but they can restore status by having a valid H1 visa, H4 visa coming back in on it. Okay.
Oh, or what if the employer files for extension for me or H4 dependent?
I don't know what you mean by that. What if the employer files an extension? What does that mean?
Yeah. Suppose my wife uses I-485 EAD, right? And then you are saying it's a parolee, it's not H4 status anymore.
Right.
But when H4 is going to expire, H1 and H4, within the US, if attorney company files for H1, H4 extension, then you can come back to H1, H4 extension.
Yes.
In the US
not within USA, no. You will get the extension, you'll travel outside, get an H1 visa and come back. You can't do it within US.
Filing extension within.
Yeah. You can get the extension, you can't get the status. Okay?
H1 and
yes.
H1, H. So it will be I-797 without alien number then?
Without I-94.
Oh, without I-94.
Okay. Sir, I gotta go on to my next call. Good luck.
Thank you.
Okay. So next one is EAD-AC21-Self Porting. Oh, sorry. There's another hand up. I didn't see that. Let's go back to the next person. Area code 214. 214, where are you calling from?
Good afternoon, Rajiv. I'm calling from Texas.
Texas. Oh, cold, huh?
Yeah, for a change.
How are you, sir?
I'm great, Rajiv. Thank you very much.
Tell me, what's the question?
So, Rajiv, my question is, similar to this one. So, I have an approved EAD at this point under EB2, but then I see dates moving faster in EB3. So, when time comes closer, can I just downgrade from EB2 to EB3
you should
in premium processing, or
well, you should do it right now. You should go ahead and do your downgrade as a new I-140, not as an amendment, but as a new I-140. That way you have both options open. Okay. Premium or not is a much longer discussion, But let's have you get it done. Keep both options open. Okay?
Thank you. Appreciate it.
You're welcome. Good luck. Okay. So the self-porting question, that is number 8. I'm currently working on EAD, waiting for my green card. Does AC21 allow me to take a lower job? Well, that's an interesting question. I want to go from being senior software engineer to software engineer. And the answer is yes, I think so, because the language of the law says same or similar. And if you have a reason to take a similar job, I think you are okay. And remember, you can still take the job of a senior software engineer when you get your green card. So right now, even if you took a software engineer's job, it's fine because the future job is the senior software engineer if you intend to take that job when the green card is approved. So you could do it that way also. And I also think that AC21 should be applicable to somebody taking a lower job, because the language of the statute just says same or similar. It doesn't say you cannot go down. You can definitely go up, that we know. But I suspect you can go down. That would be my guess. *5 if you have a follow-up question. *5. Okay. Area code 201. Are you New York or New Jersey? New Jersey, right?
New Jersey, sir. Thank you.
Yes, sir. Of course. Tell me.
So this was not my original question, but I just have a similar thing.
Okay. Sure.
So I was with employer A, but now with employer B, and this is regarding lower salary specifically. So currently, when I was with my employer A, my salary was like 1.6x, example, right?
Okay.
And now, if I join them back, it may be, let's say, 1.25x.
Okay.
So the same or similar job requirement, is it still okay?
Yes, I think so. There are a bunch of reasons why I say that. I would not be, this is my judgment. In my judgment, you'll not have a tough time if there's a 10-15% drop in the salary. There could be many reasons for the drop, and if you have good reasons, that's good. Because remember, in the same or similar job assessment, salary is just one of the factors. The most important factor is the job description. Okay?
Right. Thank you.
Good luck. Okay. Now, so this is the one that I was trying to get in touch with, a DV lottery question. There's a change, there's some problem with the names, they filled the wrong name. And I don't know the answer because we don't do diversity cases. Don't really need a lawyer for these cases usually. So if you are outside the United States, correspond with the consulate in writing. If you are inside the United States, open a service request and ask this question from the USCIS. That's all I can tell you. I don't do DV cases. Okay. Next question, number 10, is my priority date for EB2 is December 2009, which is getting closer to the cutoff. I completed the medicals again. See, these days, I think if I remember correctly, in our office, we don't submit medicals with the 485 because now the standard procedure is to, and double check that with your lawyers, but I think that's what we do. We only provide the medicals when they ask for them, because they usually ask for them close to the date when things are going to get completed. Is it safe to do a Foia request? Absolutely. I don't see any problem at all. Any idea how much time it will take? No idea. Should a downgrade option be considered, or is it wise to wait? Why not? It doesn't, it costs you money, but it doesn't affect your case negatively. File a new I-140, not an amendment, a new I-140. Why not? Get an EB3 done too. *5 if you have a follow-up question. *5. Okay. So the next question, number 11. Wow, that's a lot of information. Guys, don't give me these huge long questions. I may not have time to do all these. So I don't know what this question is. Plans after priority date becomes current and responding to RFE based on EB2 India I-485 adjustment of status. After my priority date becomes current in July, becoming current in July 2020, I am the primary, wife is derivative. We both have EAD and we are both maintaining H-1Bs. My EB2 date became current in July 2020. I sent the paperwork, supplement J, medicals. Just received a notice of action. I have not received approval of supplement J. That takes a long time. So I'm not that worried about that. Even during the normal times, that was taking a huge amount of time. Since I don't know how long it will take for USCIS to make a decision, there are good opportunities. I want to know options to switch jobs, okay? After responding to RFE while waiting for a response, do you recommend switching? Well, look, as long as your 485 is pending 180 days, I-140 is approved, you can switch at any time. Of course, if the RFE relates to your work, then you would have a problem if you have stepped away, or you might have a problem. But if it is related to you or medicals, it doesn't matter which company you are with. My new employer may not be willing to file for H-1B transfer. I have used all the 6 years of my H-1B, so I'll only have my ED. You should be still able to extend an H-1 based upon the I-140, even if the... See, I think you can do 1-year extensions. That's the way I read the law. You can double check that. I've looked at the law, and to my mind, if you have a 485 pending, you can't get 3-year H-1 extensions, but you should still be able to get 1-year extension. That's the way I read the law. Should I file another supplement J proactively? I think so. If you change jobs, you should. And if you know you're going to stay there for a while. Any other risks? No, not really. After I received my green card, how much wait time? Oh, who knows? This is really, I have dealt with this issue so many times. Just look at our frequently asked questions. I don't think there is a cooling off period after you receive the green card that you can't change jobs or start your own business. I think it's really, there is no such restriction in my mind. And I've spoken about it in detail. So if you look at our frequently asked questions on immigration.com, you will see me address this question, how soon can I leave, many, many times. And the answer has not changed over the years. For my wife, since she's my derived beneficiary, she has more flexibility. Yes, she does. My wife got her H-1B approved in 2020 quota. If her new employer is not willing to transfer, can she still activate? Yes. Yes. So if you get out of the H-1 and you want to get back into it later on, should not be a problem. She would not be subject to a quota. Just make sure that your wife actually received an adjustment of status. As long as she received an adjustment of status and her H-1 was not withdrawn before the start of the fiscal year or the start date of her H-1B, she should be fine. Nothing else needs to be worried about. Star 5 if you have a follow-up question. Star 5. Okay. So, area code 312. 312, where are you calling from?
Hi, Rajiv. I'm in New Jersey.
Okay, go ahead, please.
Just one question, which is that in these conditions, does the law prohibit us from changing location? What if the new job is in Seattle and not in New Jersey?
Is this in the context of? It's the context of H1 green card AC21? What are we talking about?
I think it's AC21 because I think that's what I worry about more than just the H1 here.
Okay, so hang on. Let me get this. Hang on. You're talking about I-140 approved, 485 pending 180 days, right? And you say, can I change jobs to California, Seattle, Arizona, Washington, D.C.? Yes, absolutely. Job location is irrelevant. When they do same or similar computation, the location of the job is not one of the criteria.
Okay. Yeah, I mean, my main confusion, Rajiv, was because this is after I requested or responded to my RFE. I guess that's what I was a bit.
It doesn't matter. It doesn't matter.
That's what my question.
Yeah, it doesn't matter. You should be fine. Okay. The only thing is your I-140 must be approved, and only your 485 has been pending 180 days. Then you're good. Okay.
Right.
Good luck.
The conditions are met. Thank
you. Bye. Okay, so L1A extension or renewal, expiration while green card is pending. So wife is on L1A. She entered in April 2015. Oh, she's coming close to 6 years. We went to India only once. Her L1A is till November 2021. Hey, wait, she should have an extra year, shouldn't she? She came on April 2015. So she should have till April 2022, right? 7 years. So maybe a few more months. Now her employer is still not confirmed if they do green card for only 5 to 6 months extension. Okay. They haven't decided about the green card processing. So questions. Should we go back to India and return to the US once it's approved? Look, if your 485 is filed while you are still here, you can continue to stay. But if it is not filed, then let the employer file the green card. You go back to India, do your consular processing, and come back on green card. Okay. The green card process does not get invalidated because you're in India. Is there anywhere around to stay in the US? Only if your 485 is filed. I don't think EB1C can be done premium processing. I'm pretty sure it can't be. EB1A can be, EB1B can be, but EB1C cannot be premium processed. *5 if you have a follow-up question. *5. So yeah, you can complete the green card from India. I don't see any problem with that. And then there is the question number 13 about EAD and AP renewal under C9 category. I don't remember the categories. I think that's the 485 through employment-based category 1. I applied for EAD AP renewal in November 2020, career tracking with delivery, no receipt notice. I know there are delays. My current EAD AP is valid till April 2021. You applied in November, December, January, February, March, April. Yeah, so not before 180 days. So you should be okay. If you are the category, C9 I think is the I-485 pending category, employment-based 485 pending. You can continue working for another 180 days, right? After April 2021. So double check with your lawyers. I don't see any problem continuing to work till what, October 2021 almost? Yeah, April to October is 6 months. Now, you should also open a case with the USCIS Ombudsman's Office. Ombudsman. O-M-B-U-D as in doctor, S man as in man woman. Ombudsman. Om as in om. Buds as in buddy with a plural. Ombudsman. So contact them, just do a Google on USCIS Ombudsman. It opens up to the case status. You can add a case request. That's what is being recommended for all receipt delays. Okay. *5 if you have a follow-up question. *5. Okay. And the last posted question I have today is, I think we'll have time. We'll have about 10-15 minutes for some more questions. So let's answer the last one. I'm just wondering how long it's going to take. What percentage of interviews waiving in this visa category due to pandemic? Right now, we don't have any statistics. Situation changes all the time, and I cannot predict how much time. Employment-based cases were never interviewed generically. They were interviewed very, very randomly. But now they are under Trump. They were interviewing everybody. Okay. So I have a hand up. Let me see who is that. Area code 203. Where are you calling from?
Hey, Rajiv, this is Suresh. I'm calling from Chicago, but
yes.
My number is Connecticut.
Okay, no worries.
Yeah.
Go ahead.
Yeah, the question is about interfiling.
Mm-hmm.
The question is about interfiling. I have an EAD and I am on EB2. May 15th is my priority date on EB2. And I currently hold a EAD and AP, and I'm working for a different employer now.
Okay.
So my question is that regarding the interfile thing. So, for example, I also have a EB3 already approved with my previous employer.
Okay.
So, in case of my dates get current, do I need to file a new 485 if I plan to go to my old employer, or interfiling will?
It will work. Interfiling will work as long as you're going back to the same employer who has an EB3 I-140 approval. Okay. So
currently I'm not with the road employer.
I understand, but if you're going back to them,
Okay.
you could go back and request that your I-140 be placed, EB3 I-140 be attached to the pending 485.
So do I need to apply 485 as a new application? Or
No. Just ask to be attached to the pending 485.
Okay. So
Okay.
No more any filing.
No repeat filing. No, sir.
Okay. Right.
No, sir. Good luck.
Okay. I just need, sir, thank you, sir. There's just a confirmation on that. So you need to apply, attach it and apply that for a supplement J, right? Is that what it is?
I'm not going to give you the logistics because they change all the time. Let your lawyers worry about that. Logistics are what they are, but it can be done. Okay. Good luck.
Thank you.
Area code 201, New Jersey. Right. How can I help you? Area code 201. Okay. Anybody has any question? Press star 5. Okay. Let's see. 3 questions. That's all we will be doing today. No more than 3. Let's start with, again, area code 201. I don't know what happened. 201, can you hear me? New Jersey, go ahead.
Yes, sir. I can hear. Thank you.
Okay, good.
My question is, so my current status is my previous employer A. The status currently is 485 is approved.
Okay.
They downgraded with EB3.
Okay.
The 140 is still pending.
Okay.
And I got the EAD and AP credit. The question is, when should I be joining back the employer A? I know that I can join anytime before the dates become correct. So if I never join them back, this is question A, and I just put once the 140 is approved, I port 485J to my current employer B, where I'm currently working. So could you just explain what is the interview process?
Okay.
So they ask a specific question.
So this is done all the time.
Why I didn't
Yeah, this is done all the time. I always have had a problem with it. I think it's a bad idea. I always discuss it with our clients in detail before they take this step because this has ramifications. Remember, the entire green card process is based upon honest intentions. So first of all, when you filed your green card through a future employer, did you honestly intend to join them? Did they honestly intend to have you join them? Why are they spending so much money on your labor certification? They are supposed to pay for it. Are you paying them something? So this creates a certain suspicion. I've never had a case denied in this situation, but if there was somebody who was sticky about the law and the rules, they could definitely raise hell over this. So be sure you can answer these questions adequately. I don't know what your circumstances are. Why were they willing to wait for you? Why did they start the green card? You were not working for them. So technically what you're thinking can be done. You never have to join them. In fact, the USCIS has a Yates memorandum. I think it was, I want to say May 5th, 2005, where this issue was specifically addressed. And Mr. Yates said, yeah, we don't think you were even required to join that employer. But those were happier days. Those were days when USCIS was interpreting their regulations more charitably. But if they wanted to make an issue of it, they could. And I don't have an answer for you. It depends upon your facts. Talk to your lawyers. Okay?
Got it. And the question B following to that is, if I join my employer A back, I can just join anytime the green card dates become current. And so can I join even just after the green card dates are correct?
The answer is yes, but you'll have the same problem. Now, if you can give them a firm date, for example, if before the interview you've already joined them, I think that would be a good thing. But if you have not joined them, the same question could be raised. Why did they do all this nonsense for you? Okay, there's a lot of work here. Why would they do that for you? And again, I think this is a highly fact-bound question. I would not want to answer this. Theoretically, you could do everything that you are thinking. As a practical matter, you should be careful. Okay?
Good. Just one final follow-up question.
I'm going to have to
If I
go.
join the-
Sir, I've got 2 more people waiting. Okay. Make it really quick.
Yeah, wait. So if I join my employer APAC, I work for them, let's go 2-3 years, and it still doesn't become current. Can I still change after that? And would that be?
Yeah, I think that's, look, now you are creating hypotheticals that should be answered by your lawyers, not by me. These are questions that are highly fact-bound, and I think even common sense says that makes more sense. At least you went to work for them. Okay. I still would have questions if I was a USCIS officer. Why did they start your green card when you were not even working for them? I still would have those questions. But usually they don't ask these questions. We just prepare for them, but they don't usually ask these questions. Gotta go. Good luck.
Got it. Thank you very much.
Area code, which one do I have now? I think 856. 856. Say hello.
Yeah, Rajiv, hi, thank you. I just had spoken. I had asked the question regarding the merger situation.
Yes.
Earlier on the call.
Okay.
Just had one follow-up question on that given time. So thanks for again. Given there is AC21 possibility, like which applies in some situations where an I-140 is pending or is approvable at day 180. If I were to transfer my, if I were to get a new job, let's say in May, because that would be by the time I would be having 7 months, and if I were to go to a new employer, would I be able to use a 485-day supplement and be able to kind of go to the new employer even though the 140 is not approved and still be able to retain my 485?
Well, that's definitely not something I would advise you to do. Okay. There is case law that says if it is approvable when filed, just because the I-140, just because you left before the I-140 was approved, does not stop you from doing AC21. But my question is, what if the I-140 is denied? What if there is an RFE? If the old employer is going to respond to it vigorously and support you completely, you can leave any time after 485 days. Yes. Okay.
Just that because the situation is unique because of the merger thing, and not technically.
Well, I won't get into that. That's a very long fact pattern. I don't remember all the details. You asked me a hypothetical. I answered in a hypothetical. You want me to go back and look at all that? I'm not going to do that. Okay.
Okay, sir.
Good luck. Yeah. That's why I want you to ask your questions when I'm reading the facts, because now I have to revisit, and that's too much time. We don't have enough time here. I'm trying to cover everybody's questions, at least to give you some guidance if I can't do a detailed consultation for you, because that takes time. Okay, now area code 618, you have a question. Where are you calling from?
Hi, sir. I'm calling from Virginia.
Mm-hmm.
Hi. The question is, myself and my wife are on H1B status,
Okay.
and we have applied for the adjustment status under my spouse application.
Okay.
And we're planning to travel out of country this summer. So, and also we're trying, if we get advanced payroll,
Mm-hmm.
we wanted to use advanced payroll when we come back.
Mm-hmm.
So if we use advanced payroll, right, does it mean we move to EAD, or does it mean the H1B status is still active and we can work after we come back?
I'll give you the answer, but you have to promise me to tell at least 10 other people what I told you. Will you do that?
I will.
The reason, because I've answered this question 4 times today already from different people. Okay. And
I missed it. Sorry.
yeah, no, not in this conversation, different conversations. So that's why I want the word to spread out. You don't have to say my name. I don't care what you say, but just as long as people get the information. So the way this works is this.
Sure.
The law says if you have a job, let's call it an exact job, system administrator for IBM. Okay. And you have an existing H1B that is not expired. You don't have a visa stamp, but you have an advance parole. You travel on that. You come back, let's say in June. And when you're coming back, your H1B is still valid. And you go back and take up the same job that you left, which is system administrator for IBM. Even if you entered on advance parole, we consider you to be on H1B. Okay. You are considered to be on H1B. You can do an extension of an H1B within the United States with an I-94 Let me think about that. Yes, with an I-94. So no question about that. The only time you would run into trouble is if your 485 is denied, then you would have to do an H1 extension and get a visa stamp and come back. Not a big deal. It's a lot of benefit to travel back on advanced parole because you don't have to apply for a visa. So it makes a lot more sense.
Okay.
Clear?
I got it.
Make sure you spread the word, okay?
Yep.
Good luck.
I will. Thank you.
Good luck.
Thank you, sir.
Okay, you're welcome. Okay, I think we are done with the questions. We had one extra one. Very good, guys. I am so pleased. 129 and we're done with all the questions. Wonderful. Within the hour. I'll see you guys again in 2 weeks. Stay well. Keep those masks on. And it's a privilege and a pleasure talking to you all. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.